the downsides. Anyways, listen to the recording. I haven't put the screen in, but it's there. It's going. Let's do this. Sorry, I'm not going to pause the live stream. We're still just setting up the computer. So if anybody's hearing this, it's not actually dead. I've just already started it and we're just loading it up. So it'll be like 2 minutes. It was very funny. Did we do intellectual property last week? Was that the week before? Yeah, it was IP last week. So, funny story. So I got, in fact, I can leave this on the recording. I got one of those complaint things from Google/YouTube for copyright infringement. So the lecture on copyright, I got a copyright infringement. Think if you can, see if you guys can work out why. Why did I get a copyright infringement on that live stream? Yeah, have a think about that one. What did we do last week? We played music. We played music on this computer, and I didn't mute that microphone. So that live stream got Men at Work song. Ironically, the one song that is the basis of Australian copyright law got an infringement notice. So, of all places, in New Zealand. So that video, if you happen to be in New Zealand, between now and the exam when you're studying, you won't be able to listen to copyright video. Live stream, which I thought was really quite cute. But anyway, so I guess it's also useful to know because the software is so good these days. If you're doing streaming, if you're recording stuff, it'll come up. It'll literally come up and ping you and tell you off because you can hear things in the background. Oops, that should say 12. It say 12 when I fix the light. Let's go.
So you know next time when you turn it off up there, you can still hear it playing.
Yeah, in the background. Yeah, of course. Okay, rules of money. So this lecture is basically just about, I guess, it's kind of a miscellaneous collection of topics to do with money, currency itself, and to do with enforcement and debt and how the rules for that stuff works. And this, it's bread and butter stuff. And as I just point out to the rest of the class, this will not be in your exam. So I just love that moment when you say that to people and they go, oh no, just turn around and just walk out. So that's like, see ya. So it's useful stuff to know, particularly small little things. You probably take away a couple of small things from this, and I hope it's useful, ongoing in terms of your life. I found that I've picked up things here and there, and particularly I've sort of cherry picked some stuff that I've picked up, particularly studying law and the litigation aspect of stuff, and how you go about getting money off people, because it's just cumbersome. Okay, and that largely flows from the fact that the law doesn't really impose duties. It's not really about, it's a free country. It's not about imposing duties on people. It's really about everyone has this packet of rights. Trouble is, as famously said by this jurist called Oliver Wendell Holmes, that the right for me to flap my arms ends where your nose begins. That idea that we all have rights, it's great. Well, that's fine. We can go and walk around and do whatever we like. That's not problematic. It is problematic when our rights overlap each other. I went to a function with the Indigenous School last night, and one of the local members, local elder, was on a dispute. He was the non-judicial member in QCAT when I had a fence dispute. It's a fence dispute. And the trouble with this fence dispute, just by the very nature of it, unfortunately, I have 5 neighbours, and also very unfortunately, one of them didn't want to pay for the fence. There was a weather event, not this, it was actually last year. Maybe there was a rain event at the start of last year. Just the only place in the city we happen to have a mini tornado come through and it knocked our fence down. And that fence, trying to get money out of people was very, very, very hard. And it ought to be hard. It's hard to go and take stuff off other people. The law actually sets a pretty high bar in relation to those things. And so we'll talk about debt, we'll talk about enforcement, and the final topic, which is on bankruptcy. But we'll kick it off though when talking about banking system. Banking system is super important in contemporary commerce. And so There are some stat definitions for these. Banking used to be common law. In fact, I wanted to find out more about banking law when I was teaching the subject last year. So I went to the staff library and I found the book that was there on banking law. And I started reading it, and it was a beautifully old sort of bound book, and I'm reading it. And it was talking about the common law banking rules. And common law banking? That seems a little strange. You'd think the federal government would have stepped in a little while ago to regulate that. It turns out that book was published in 1906. So that book has been sitting there. It's now in my office now, and it's over 100 years old. It's scary, actually, and they look just beautiful. You could literally look just like a contemporary report. You just pick it up and read it, and it's you don't actually notice until you start reading the content just how way out of date it is. But interesting nonetheless. But that's common law definition of what a banker is. And again, this lovely book on banking law talked about bankers, which is a term that we just don't use at all. We use the term bank rather than banker. We don't think of bankers as individual people. And in fact, in Australia, the statutory definition says that it must be a company. So there we go. It's that Banking Act 1959, subsection 7 and 8, must actually be a corporation. And both the corporation's power and the banking powers are exclusively the domain of the federal government. So the federal government controls the money. Federal government controls currency anyway. And all of the banks, the federal banks, go back and report and are governed by them. Now, the banks, as you guys may or may not be aware, they've had a little bit of scrutiny this year, the last 12 months. They had something called a Royal Commission. And do you guys kind of know what a Royal Commission is? I don't know, just in terms of the lay sense. Most people are aware. They usually appoint somebody, usually an ex-judge. But the judge themselves are still operating on a personal capacity. So they know the law really, really, really well. And they're given powers very similar to what courts have. But they're essentially in what's called an inquisitorial mode. They choose who to call and what evidence to consider. All right, which is quite the antithesis of what a judge normally does, who never gets off her or his seat. They sit there, the evidence is brought to them, and they can't consider other things. So a Royal Commission, Parliament has to set these things up. Usually they create a special statute, gives that person power, and a pot of money to go through this. Royal Commissions are very expensive. And so that's why you will hear stories, usually from one side of politics rather than the other, when something issue comes up. Oh, we need to get a Royal Commission. Well, they're very, very expensive. And again, this is a free country. We don't, strictly speaking, want people to be able to be forced to go and give evidence. All right? If you are called for a Royal Commission, you do not turn up, you're in contempt. They're given contempt powers, and they can go and do things. Put in prison for going and not turning up to those things. And so the Banking Royal Commission, a lot of people turned up. They did. All of the CEOs from all the major banks, and they were grilled by that panel over a long period of time. And the net result was banking needs more regulation. One of the noticeable things about this country is where the power sits. In this country, the banks are one of those organizations that has an unnaturally large amount of power. I worked for a bank myself for a few years, and they solve problems by throwing money at them. And if you're a problem solver, it is a wonderful place to work. And that's pretty much their entire model. You cause problems, see you later. We'll give you strong incentives, financial incentives, in order to align very carefully with the bank's strategic directions. Yeah, they have a lot of power, and they essentially control the economy. If we think about the fraction of money, of physical coinage, I think it's well below 1% of all money in circulation is physical. When the actual physical banknotes that are printed. You guys are probably aware there used to be this thing called the gold standard. That sound familiar? Vaguely. Used to be that in order to guarantee for any given country or entity that could print money or bonds, they had to guarantee the underlying value of that in gold. So there was a place in the United States called Fort Knox. They kept a lot of gold there. A lot of gold. But in the 70s, I think Nixon, maybe Ford, around about that time, they basically got rid of it and said, look, the US is strong enough as an independent a country with an independent bank. So you guys are also aware, again, most of you guys have studied economics. I think I've probably asked the question a few times. You're aware of the zero risk investments, accounting students. What's the only zero risk investment? Government bonds. Why is that? Because if a government needs to pay the interest, what can they do? Print more money. Brilliant, isn't it? It's a great system. Yeah, they tried that, and good old Mr. Mugabe tried that. Remember those stories about the $1 trillion notes? $1 trillion notes? That's what happens. You end up with hyperinflation if you print money. So it's something that countries have recognized basically in the 20th century. You need to have independent banks. Independent banks. Banks can't be easily swayed by political means for that exact reason. So, well, strictly speaking, yeah, they can print money. In practice, they don't. But anyway, banks have lots of power. What are banks all about? Well, this is a list on the screen there somewhere that talks about what the bank has to do for you. We have to deal with these things. We have to give them our money, and hopefully we get our money back. It's been a while in Australia since they've had what they call a run on the banks. Have you heard of runs on the banks? Everyone goes, yeah. I think Hungary had one relatively recently in the last 5 years, where they were worried that the banks were all going broke. And if you have this fear, if you don't get your money out now, you're going to lose it. What do? You quickly run to the bank. And that's literally why it's called a run on the banks. Everybody goes to the bank, get their money out first in. Yeah, exactly. Y2K. And also there was a little bit of fear after the global financial crisis, or during the GFC. There was a little bit of fear that might happen. And I think that most of the central banks got together and said, hey, look, we need to be clear. We need to be jointly tackle this and get the political leaders on side to sort this out. And to be honest, the world should be very, very, very grateful that Obama was the US president and not Trump. That would have been an absolute disaster for the world if that was flipped around. Anyway, that's my 2 cents on that issue. Okay, so what do? When you're a customer, generally, when a customer comes in and wants their money, you give it to them. That's what banks have to do. They have to do that. They have to follow lawful directions of the customer to do things, particularly in relation to the transfer of money to third parties. And you can do that in a variety of ways, and I'll talk about checks a little bit later on as well. Secrecy. Banks are fiduciaries. They have your secrets, and they are not to give them out to other people. And that's part of that, this idea of this things like Facebook. Remember, we've got this whole contemporary concept of our private information remaining private. And so banks have a duty, common law, I think also under the statute as well, but certainly under common law and equity, to basically keep their mouths shut. And it can be tricky. This can actually be a little bit tricky. When the bank holds the accounts for two entities, and one of them is going and borrowing money to do things in relation to the other. And so if these guys have lied to each other, the bank have got something of a problem. And this has come up from time to time where the bank, because they hold both accounts. Hey, look, we want to go and borrow some money in order to invest in this business here. And the bank knows that this business here doesn't have X, Y, or Z dollars. But they still are in that situation, still bound to essentially called, I think in accounting we use the term Chinese walls. Is that a term you guys have come across? Chinese walls, that sound familiar? It's where you've got an organization, usually a large organization, that's dealing with two sides of the same matter. For example, a big law firm, maybe better, big accounting firm is dealing with, law firm, accounting firm's fine. We've got a large corporate client that's dealing with another large corporate client. All right, and there may be some sort of conflict if that information seeps between the two, that you have to set up control mechanisms in place in order to stop that information from moving in between people in the same organization. Surely you guys done auditing. Does this not come up? Is this not a thing in contemporary accounting practice? I'm sure it is. Where you specifically set up structures so people don't, in the same organization, don't swap information. I'm getting blank looks. Really? Most of you guys have done auditing at the undergrad, or you still got to do that? Is it next semester for those doing accounting? You guys are all doing auditing though for the CPA students. You should do. I'm hoping. As an elective. Oh wow. Wow. You didn't do it. Okay. Wow. Okay. Oh right. Oh yeah. Sure. That's fine. Yeah. My very hazy memory of undergrad auditing, but for us it was mandatory. Okay. What else? Exercise reasonable care and information pricing. Do you notice this thing sound vaguely familiar? Exercise reasonable care kind of sounds like the duty that you might have under the tort of negligence. When they're giving advice, they have to operate at the standard of a reasonably competent financial advisor or bank or what have you. That they have a duty, tick, for the first element of tort of negligence, and the appropriate standard is that of a reasonably competent bank. I went to one of the banks, myself and my now ex-partner, to talk to the bank, it was the ANZ, about a loan and what we would need to do for a loan. She was very much ahead on her mortgage. All right, so we said, well, look, we need about this much money. And her mortgage was ahead, right? And just in the space of that conversation, I'd asked the question, so can she draw down to this amount? And the guy said yes. And unfortunately, I didn't record that because when we went back, after literally signing a contract to purchase residential property, we were told, no, you can only draw back up to this amount. No, we definitely told you that. No, you didn't, because I wrote it down. And we literally materially changed our position as a result. Evidence would be difficult because I didn't have any evidence. It was basically my word against the bank's word. And like the other times we've talked about this, the evidential burden is always borne by the plaintiff. I need to prove on balance of probabilities that piece of information was given to me. All right. In other words, they'd fallen below the standard, the breach component of that. But so banks and bank offices, and look, it is pretty heavily regulated. Bankers and the little personal bankers and the residential and the commercial bankers, they have to go through quite a lot of training in order to go and give financial advice. We do appreciate it is high risk. When people go and seek advice from banks, if the banks are bad at doing that, the consequences for people in their lives can be catastrophic. And so we do appreciate that's an important part. Give a customer a reasonable notice for closing the account or basically for winding the thing up. You guys are probably aware banks are closing branches left, right, and center. Everything's moved to the internet. Fewer and fewer people are needed. And I've noticed down in Aikenvale, you remember down in Aikenvale, there used to be a Westpac, and there was a ANZ, and there's a NAB, and now there is just a NAB. And the one, which is basically the closest one from the Centrelink building, and the staff there, they're kept pretty busy. But generally, bank branches, because the services are less and less used. Most people do things over the internet. Documents. Again, this doesn't come up much these days. You can go and actually deposit things with the bank. Now, this used to be a much bigger component of what banks would do in their sort of day-to-day business. And in fact, in Queensland before 1974, you would still have what's called deeds, a deed for your land. And a deed is essentially a special document that says this person had this land, and this person had them before that, and this person had that before that, and this before that. And when you would buy property, you would get people to witness your name be put on the deed. And that physical document was taken to the bank in order to secure a mortgage. Right? We don't have that these days. We have a thing called the Torrens system, where everything's registered, and whose name's on the register, the central register in Brisbane somewhere, I can't remember where. That person is the true owner of that property. That's how that works. But it used to be whose name was on the deed. And so you can imagine these documents were quite valuable, and particularly when the bank has taken security, mortgage on a property, they hold on to those things. And it used to be this famous moment in people's lives where you walk into the bank, you pay the last dollar off your mortgage, and they hand back the deeds. And you get to walk away and walk home with them after 30 years of paying off your mortgage. But yeah, so banks, I believe they still do this and offer these sorts of services. Custodians, I've I worked for custodians, but it's not a big part of contemporary bank. Yeah, those things. Yeah, that's American films too. Those things there. I said I don't know. I've never even thought about things like that in terms of the banking looking after it. I believe they still offer them. I believe they're actually obliged, even though it's probably a loss-leading service. I believe they're still obliged to do those sorts of things. All right. So that's what the bank has to do. What do we have to do? Forgeries. We have to take reasonable care when we're doing things in relation to the bank. The bank still has rights. And the classic example of this in Czech law, which I'll talk about in a little bit, the Computer Accounting Society, I can't remember what the last word of the thing was, but they'll call it the Computer Accounting Society case. Why? Computer Accounting Society Holdings might have been the third name of that entity. What's the trouble with that is the name of the entity, if you abbreviate it. If you write a check out to the Computer Accounting Society Holdings, cash. So that's why people would do that. I'm not kidding, this actually is one of the leading cases on care that you need to take as a bank customer. And one of them was, this was legit, it was the name of the organization, and they wrote the abbreviation, and somebody picked the check up and took it and cashed it. Who's at fault here? Well, turns out actually the Computer Accounting Society, because their name, when you got a name like that, don't be careless with things like that. And that's really how that works with things like checks. Make sure that you check signatures. Make sure that you actually go and are diligent about checking the identification of people in regards to instruments, because the banks are allowed to put their hands up and say, nah, you guys were well below, you fell well below the duty of care to us. Draw checks in the form free of ambiguity so as to not mislead the bank. Oh, the other thing is, who's written a check recently, like in the last 12 months? Anyone? Anyone written any checks? Justice? Written checks recently? No. Oh, Mum and Dad's write them. Down the end, lad. What were you writing a check out for? Can you remember? No, you can't remember at all. Those things. I teach trust accounts. So it's the lawyers. I have to literally teach them how to write a check out, because the trusted lawyers have to learn how to do it. Even though all of theirs are electronic as well, there's not many practices, but the Law Society demands that we teach both check law in the broad sense, as well as trust accounting, manual trust accounting, drawing, handwriting stuff. And yeah, so that's what we tell all the law students: make sure you double check all of these things, because you can be held liable. Oh, and you have a positive duty. You actually have to rock up, call the bank, and say, oi, this doesn't look right. So if things don't look right in regards to financial instruments, someone dodgy comes in, not sure about their ID, you've got a positive duty to call the bank. All right, what else is there? Go to banking practice. Now, my lecture frame's off. Oh, that's quite funny. All right, this, the interesting thing about some of these codes, you guys are aware, and again, the economists might be able to explain this better than me, the idea of voluntary regulation, that idea that players in a particular market or a particular industry realize that if they don't regulate themselves, the government's going to come along and regulate them much more harshly. And so that's why it's not uncommon in industries to have things like this. The classic one I love at the moment is my beef with IGA across the road. Most of you guys have shopped at an IGA. Have you guys ever swiped something and it's the wrong price? Have you ever seen that? Like that? Was the price lower or was it higher? Oh, come on, you should never have to think. It's always higher. It's always higher than that. The thing comes up and I go back and so this girl, the same girl, has to put up with me saying, oh, can you change the price on this one? Can you change the price on that one? Can you change the price on this one? I suspect no one checks. Now, interesting thing is, supermarkets have one of these industry codes, and it says if it swipes, like at the low price, I think you just get given the item for free. or something like that. It's outrageously consumer friendly. All right, and when you walk into IGA, the little sign, IGA does not subscribe to the industry, thing like that. Coles and Woolworths do, IGA does not. And appreciate, you guys have studied law for, 12 weeks? These codes are not law. They're industry practices, and particular entities in that industry can choose to sign up to them or not sign up to them. IGA is doing nothing wrong by not signing up to the supermarket code that Coles and Woolies do. Coles and Woolies make way more cash. They make way more money than IGA do, and they can spread losses around much more easily. They don't care from a fundamental perspective if they have to refund things all the time. It doesn't matter. Whereas with smaller entities, it does matter. Somebody comes in and $50 item is tagged wrong. That's $50 from your back pocket, and that can be much, much more problematic for small businesses. So anyway, the banking code, it's basically setting out these terms and conditions and making things more visible for people, for them to be able to see what it is they're getting themselves into. You hear these stories, these old law cases about people signing up for these terribly unfair mortgages. And we've also learned in this subject just how harsh the common law is. It's fundamentally set up by the courts for people who sign up to stuff to do what they say they're going to do. And what we've found, though, in practice, banks have lots of power, and individuals borrowing from those banks have stuff all. And so these sorts of codes have come into place to try and offset that power balance. A bit like Australian consumer law type things, or in fact, indeed, the supermarket codes. Things like that have come into place. We accept that it's got this mismatch of power. So a bunch of things there, basically giving information, disclosing fees, process instructions about direct debits. That was always a real problem. In fact, you guys, I don't know, anybody's lived in Australia for about 10 or 15 years, the banks have slashed their fees massively in the last 5 to 10 years. In terms of, we used to pay a monthly fee. Monthly fees, I don't think any of the banks do that these days, do they, with most accounts? I found that even setting up, literally, I've set up company business accounts, and they don't charge monthly fees. Just like, here you go, just go to. So the banks have become much more lenient. I think they've just realized that the visibility, and through being, really, really mean in terms of charging fees, is just a bad look. It's not worth it from the bank's perspective. They want to seem like they're the good guys. They'll make it up somewhere else. They'll make it up with their loans. But in terms of the little fees that we see when we go in, they've tried to really, really cut back on all of that. Yeah, it could be actually. And one thing, the credit union up here, these guys, has anyone bank with these guys? Bank Misu. It's this little bank. It used to be a credit union, and to be honest, they're pretty hopeless. In fact, I stopped banking with them when they started charging a monthly fee. I'm just like, well, what are we doing? Because all the clubs and societies used to go there, because you just have your AGM, walk into the bank, change the signatories over, and that was the way they did it. But it's really hard being a little player. They've changed from being a credit union to an actual bank. They're actually an ADI these days. Very, very hard to compete in that space, that sort of space. Because if you think about the amount of loans they would have to keep that branch open is just huge. It's phenomenal. And then they've got to compete buying money at a wholesale rate from the bigger banks in order to then on-sell it to people. Smaller, very, very hard business to get into. And look, you guys, again, for strategy, you talk about barriers to entry. Remember Porter's 5 Forces? You guys know what I'm talking about. Michael Porter's about doing business strategy, barriers to entry, barriers to exit. Massive barrier to entry in the banking sector. You need a lot of cash to set up a bank. And so that's why these things end up being heavily regulated. And this is their attempt to regulate themselves to stop Parliament from doing it. Didn't work because we had a Royal Commission and, oh mate, I remember working for one of the banks. This is the saddest thing. And I was in project team that would be moved all around. And I remember one day sitting next to the traders. The amount of times the traders would come in and they'd duck down and whisper to each other, oh, I'm just about to do a trade on such and such. Why don't you go and buy some? I'm like, no. Don't ask me which bank. I don't want this recorded. Sorry? Oh, good question. I'm going to have a little look. Hi, chat. Have a little look. It's really hard to see, isn't it? Hang on, chat. Let's go and have a little look. Kind of foolishly didn't pop it out. How did I pop out the chat? I felt a little bit bad because the way the chat works. Oh, it's Jill. ANZ still do. Bendigo does for my home loan. Thanks, Jill. Thanks, Jill. Yeah, they are. Yeah, they still charge. Yeah, they still do charge fees. I actually have to get a mortgage. I've got to get one next week. I'm not really looking forward to this. I gather it's not much fun, but anyway. All right, going to move on. Checks. Again, checks are not things that we use very much these days. I went and found my check butt a little while ago. The last check I wrote was in the year 1999. So it's been a long time. A long time since I've written a check. But a couple of things you need to know about checks. In terms of what they are, a check is an instrument that is an order. It's a demand that the bank do something. Demanding that the bank pay a sum of money. All right. So strictly speaking, and this is written in the Checks Act, it's an unconditional order in writing addressed by a person to a bank, signed by the person giving it, and requires them to pay on demand a certain sum of money. And so that's it. It's basically an order. It's an instruction in order to tell the bank to go and pay money to someone else. All right, and it's a little bit complex in terms of how they operate. And appreciate that check and check law is actually pretty old. It's been around a long time. And just the key thing to note, I guess the real takeaway from this, right, is that a check is an instruction. It's an order. It's a demand for that money to go and be paid according to the instructions that are given with it. And those instructions, usually by default, to pay the person that you sign the check over for. I go pay for Hannah $10,000. When I hand you the check for $10,000, it's an instruction from my bank to pay you, the person whose name's written on it, that sum of money. All right, that seems pretty straightforward. But you can do other things with checks. You can actually go and transfer them to third parties. And the idea was that they were flexible like that. This instruction for my bank to pay you, you can on-sell to another person, transfer it over to them. Now, I can give instructions when I write the check out that it can't be transferred like that, by putting crosses on it, putting not negotiable, giving additional instructions to do with limiting its ability to be transferred. And look, we teach it to the law students. I would be very, very reluctant to try to be too tricky with checks in your professional and private practice, both in your professional practice as well in your private life. And the hilarious story, not really hilarious, quite sad story, is the Associate Professor Tom Middleton, who's taught check law at JCU since like 1990, knows the rules very, very well, as one might imagine. And he went into the bank. I remember we told the story a couple of years ago. He went into the bank and had to have an argument with the cashier who refused to do one of those transfers, would have been transferred over by signing it on the back to a third party. And they were like, no, we're not going to pay. But, he's trying to argue, no, it's section 57 of the Checks Act. This is passed over. And they're like, no, they don't care. From the bank's perspective, it's too complicated. They didn't care. So even though the guy who's been teaching check law here for like 30 years, you can rock up with being completely right about something. But at the end of the day, the banks have to still sign it off. Strictly speaking, they're not supposed to, but if you're trying to talk to a 19-year-old cashier and trying to explain to them that they'll find out, not sure of that, good luck to you. Okay, All right, so here's the different types. I'll go through them, but my personal advice is to don't get too tricky with checks. Get them, cross them, putting the 2 lines through them, right? Not negotiable between those 2 lines, and just basically to make it an instrument that tells the bank to pay the person that's written on. Don't get too tricky with checks. Okay, an order check. All right, so there's really 2 types. There's a check. I thought about putting a little picture of one on there. There is a little in any given printed check. Checks come on a pre-printed form. The bank issues you pay a fee. They issue you with a book, and the book has a check on one side and what we call a check butt next to it. And the idea is that you write the information on the check, and then you write essentially a copy of that information in the check butt, the amount, the person you're paying, the date. One of the things you can do is where it's got this little thing that says or bearer. You can cross that out, or you can leave it open. If you cross it out, if you don't cross it out, by default, the check is written to the person's name or any other person who presents that check into the bank itself. So any other person can go and do it. But by default, it has to go into the named account of that person, of that thing there. Although if you have that thing and it's not crossed, this person doesn't have to put it, strictly speaking, into an account. They can rock up and then cash, essentially take the money without it needing to go into an account. If you cross it, it must go into a bank account. And if you write not negotiable, it can't be transferred to another person by writing their name and signing it on the back. Those 3 things interacting with each other, like I said, I'm pretty sure most people don't really know how it works. Generally, you find if you get a pre-printed check, you guys may get this too, you get a refund from the power company or the tax office. Again, in this day and age, they almost always go straight to your bank account. But you can get a check. Medicare used to send refunds. Not sure how people are with Medicare. Oh, wow. 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 Jury duty. Oof. Yeah, the department, we think that lawyers are real slow, like behind the times. There you go, Department of Justice. Good job. Oh, DJ, behind the times. All right. Yeah. So you can, again, if these things aren't crossed, you can write on the back, I transfer this check to this particular other person. And you write your name, you sign it, and you deliver it. This is where it says delivery. You have to physically go and give the check to someone else in order to transfer that over. Title to the check. Now, when we do contract law, what are the 3 physical elements of a contract? Hashad, what's the 3 physical elements? Consideration. Yeah. No, strictly speaking, it's offer, acceptance, and consideration. Those are the 3 things. Those are the physical elements. The others are either legal or mental elements. Intention to create legal relations, capacity, mutuality, and legality. The 3 physical ones are there, and a worthless check, which is an order for a bank to pay money where there's no money in that bank account, is not valid consideration. What does that mean? It means that if somebody gives somebody a check, all right, that is worthless, that is just essentially a worthless piece of paper, it's not consideration. So that means if it's not consideration, there's no contract. And so that's probably one of the few tidbits you probably want to remember about this. Because remember, a check is just an order for your bank to pay somebody. If there's no money in there, the check, what's the colloquial term we use for that? It bounces. And as a young guy who would write checks out and then spend the money because I was useless, my checks would bounce all the time. And the bank stings you like $50, which is quite a lot of money in the 90s. And those contracts aren't actually contracts because there's no consideration that's been offered. So strictly speaking, title doesn't pass on stuff. And so if title's not passing, you've written out a blank check and you've bought a motorbike, they can just come and get the motorbike and you've got no rights. There's no contract. So that's just a thing to leave in the back of your mind. You can convert them as well. Again, that bearer check converted to an order check just by crossing the little 2 lines that say or bearer. Cross that out so that they can't. when the thing goes in, it has to be that particular person who's named on the check. All right, other rules. This stuff is really not very exciting. Check loader. I mean, it's in the subject. I don't examine it because I personally didn't find it very interesting at all. Studying it as a law student. And it's so rare. So every year I keep saying, oh, this becomes rarer and rarer every year. More and more like an abstract thing. But okay, crossing with two parallel transverse lines must go into a bank account. That's what the two lines mean. But you'll see this. If you get a printed check, again, from doing jury duty or from getting sometimes shares. If you've got shares and they pay dividends, they'll give you a check, and it comes in a little printed form. And it'll have those two lines, and it'll have not negotiable written in it. They'll all just have that. Just they don't want the hassle of somebody receiving this check in the mail and then being able to go and cash it. The people paying the shares, they don't want to deal with that. Okay. There you go. When it's not negotiable means that you can still assign. It's yeah. Title of the check can't go to a person that's not named on the back of the check when that's sent over. And account pay only means account pay only also means if something dodgy is happening at the bank and somebody asks for a check to be cashed, if you put the words account pay only, it's an extra protection to essentially make the bank more liable for not checking in those situations. There's a case, it's an old case, that puts them on notice to make inquiries. I don't like check law. I didn't like it when I studied in undergrad. To me, it just, when you write a check, put the person's name. If it's the Computer Accounting Society, write it out in full. Put not negotiable in between two parallel lines, and cross the little thing out that says or bearer. Just cross those things out. Just do those three things. And when you give the check to somebody, and this is the important bit, if the check gets lost and it needs to be reissued, get it cancelled at the bank and then just give them another check. Make sure you call the bank up and make sure it's definitely been stopped. The other thing to note with checks, and this is a very important practical thing, make sure before you give the check to somebody, you've written the information down on the check butt. Because if you do that, and this is the sort of the horror story in trust accounts, because we, as solicitors, writing these things out is a disaster. Once the check is gone, it's gone. You can't usually retrieve it to get it back, to get the information and put it down. So that's really it, really. Just be commonsensical with these things. And to be honest, in your life, try to avoid them. I don't know if I have a slide on bank checks. No, I don't. One thing to note, a bank check works different to a normal check. A bank check is something essentially you purchase from the bank. It works just the same as a check, and it's quite common if you're doing things like buying land, where you've got to go to what they call the settlement, and the seller and the purchaser, so the seller will be demanding money, and that money is usually in the form of a bank check. These days they're starting to do the transfers directly as well, so again that may become less and less. But the idea is that you, as the purchaser, can go to your bank and say, I would like to buy an instrument that looks like a check and pay $300,000 for it. And so they'll print it out in a super special piece of paper, and it looks and operates like a normal check, except that rather than the money being an instruction for the bank to pay a third person from my account, I've already paid. I've already said to the bank, I want to buy this bank check. It's actually an instruction. It's basically, NAB is my bank. It's saying the National Australia Bank will pay the $250,000. All right, so it gives this extra level of security because bank, in theory they can not honour their own checks for whatever reason, but in practice they don't. It means that it's not relevant at all whether I have any money on my bank account or not. I've gone to my bank, paid the $25, got a bank check, and that's the instrument that I'm taking to the settlement. That's how that operates. That still happens. It's still a pretty common thing in conveyancing. All right, I suppose I don't have a slide on it, actually. Probably should do that next time. All right, what is much, much, much more common? Oh no, last time you went to the supermarket, how did you pay? No cash. All right, so physical banknotes. Yeah. How did everyone else pay? Most people, what do you pay when you go to the supermarket? Go to IGA? PayWave. That's essentially what it is. Most transactions, consumer transactions, PayWave. It's kind of weird. If you stopped and asked your young self, and this is probably maybe fairer for the older of us in the room, if we went back to when I was young fellow in the 80s, for example, and it said to me that, eventually we'll have these cards, we'll just walk in and just go beep and it'll take the money off our bank account. They'd think you're crazy. They're absolutely crazy. What do you mean that money just comes out? What's to stop somebody from stealing it? It's like, well, yeah. What's to stop somebody from stealing it? I mean, having CCTV footage everywhere doesn't, that brings it down maybe a little bit, a peg or two, but essentially, if you try to explain this to yourself as a kid, the concept seems crazy. You get a little card, and you just walk up, and it's hooked up to your account, and just go beep. You don't need a PIN number. Yeah, $99, anything $99 or less. In fact, I had this great moment on New Year's Eve where I went and bought like 4 jugs of beer. And the woman said to me at the counter, I know, from the casino, it was I think it was 4 or 5 jugs of beer. And when the woman said to me, will PayWave be okay? I'm like, yes, because it meant that it cost less than $100. I was stoked. I was like very, very, very happy. So that's it. And I think it was 80. I think it started at 80 and they bumped it up to 100 just like 2 months later or something when they realized, this works. It just works. That's how the system, and I don't know what's going to happen in the future with that, whether it'll be phone-based. You can get little phone apps, I presume, these days that just go beep. You can do it now. There you go. Is it more or less common? Do people do that? Do you use it? Anyone else? Okay. The chips, nose, and the eye. Oh, my phone's pretty useless. Oh, yeah. Oh, nice. And you swipe it through. Oh, very cool. I suppose that's...
In America, it's only the last couple of years they started putting chips on the card.
Oh, yeah, no, they're well past the time. It was kind of funny. I have to say something I'm a little bit proud about. Because of the size... the isolation and speaking English as a first language, New Zealand was always the trial nation for any new banking product. So we had EFTPOS cards way back in the 80s, and so we always found it really funny. Just when I remember moving to Australia, I'm like, what do you mean I've got to pay cash for things? It was a bit of an eye opener. It's about 10 years behind, So these days, one of the key things to note about this though is, while debit cards are hooked up through the banks, they have dispute mechanisms that they go through. More and more, the mechanisms that you use for resolving disputes involving things like PayPal and eBay are governed, and the Visa company are governed and dealt with through those entities themselves. So the dispute that you have with a person who's ripped you off is often managed completely through PayPal, or completely through eBay, or completely through the Visa things. And so, look, I think it's a really important point, because we've spent all this time learning about contract law, the fundamental rules of contract law and offer and acceptance and tension and breach and performance and misrepresentation and all of that stuff. But for a lot of the things that we buy, we don't really use that. We go through, and you'll find that PayPal and friends are very, very happy in most situations to refund you for a whole bunch of stuff. They go and take it up with the merchant. They're the ones that go and enforce these things. And so it ends up being quite a useful mechanism, particularly is that these are multinational entities. And you'll find that their terms and conditions are, these transactions are governed by the laws of Delaware. I don't know what the laws of Delaware are. I probably couldn't find it on a map. But most of the time, it doesn't matter. So just make note that in terms of small, regular transactions, a lot of the stuff that we use in contract law, particularly if it involves international type transactions, isn't usually going to apply. Usually, you're going to have to go through PayPal, through Visa, through eBay, those are the entities that govern it, because they're the ones that essentially manage the systems themselves. The contract that you often have is not, strictly speaking, with the person you're purchasing it from. It's often governed by the fundamental contracts you had when you signed up to your eBay account. And similarly with credit cards, the Visa company and American Express, they have particular contractual rules. When you get one of these cards, you enter into arrangement with them. That's a contract that you have. And so going and dealing with those things is usually based on their own terms and conditions, and you're following your contractual rights that you have with the Visa companies, or the Visa or American Express, rather than often the third party that you're actually dealing with. Sometimes they say, go away. Look, you've just gone to bought a $55,000 Mercedes, and for whatever reason the Merc doesn't turn up. The Visa company might say, no, it's your problem, mate. And that kind of makes sense for larger things. Larger things are really for up to do. Much like with contract law, we have for small amounts, things up to $40,000, even if you're a business and so on, there's small amounts. You go and you can use these consumer protections, you use these basic rules, and it's all governed by statute as well, Australian consumer law. When you have big transactions between big, powerful parties, the gloves are off. We expect powerful parties from dealing with contractual negotiations with each other. They have lawyers. They can use the rules of ye old contract law, and they do. That's how they go through and do that. So that's my 2 cents on that, because I get asked a lot in these sorts of classes, I'm having this difficulty with this camera that I bought, or this difficulty with this hotel that I booked, and those things there. And often it's go through the merchants. They have a vested interest to solve your problems, especially for small amounts. All right. Hasn't been such a thing this year. Last year it was a huge thing. Everyone's all, this, that, the other thing about cryptocurrency. Cryptocurrency is not a currency. That's the first thing. It's not money. All right. So the transactions, the way that we go about doing these things are essentially a barter. It's a swap. We're just swapping one thing with another thing, neither of which are money. All right, so what does that mean? It means the Sale of Goods Act doesn't apply in relation to those things. We're swapping stuff. All right, so that's the first thing you need to know. That might change. I don't think it will, not in the foreseeable future, but it's not money. And so you can accept it, you can take it, you can do whatever you like, but appreciate that the type of contract that you have, if you are taking cryptocurrency for your business, is that of a barter. It's not governed by Sale of Goods law, because people aren't paying things. You're swapping stuff. And so a lot of the principles of contract law, those basic principles, offer, intention, declarations, and so on, will actually apply in those situations. So just leave that in the back of your mind when you're doing those sorts of things. The other thing you find, just from a practical consideration in terms of cryptocurrency, is that there's no safety net. If for whatever reason there's a technical error, you've given the stuff away and the thing doesn't come through, you've got no mechanism to go and complain about it. You either got the thing or you didn't get the thing. And so you guys are aware how these things work, these whole lot of distributed ledgers and cryptocurrencies. The idea that, okay, I'll give a quick session on what cryptocurrency is, shall I? All right. I was being exposed to this since about 2005. I looked at it, wish I'd bought some. Boo. But essentially, you guys know what ledgers are, right? Yeah, we're accountants. We know what ledgers are. So if you could just imagine, you've got a ledger, all right, and it's basically a ledger of all of the transactions that have happened from day zero. All right, where some person says there now comes into existence 1 Bitcoin, for example. And that person trades some fraction of that 1 Bitcoin off for whatever else. All right, the only things that are in there is the ideal, usually the key of the person that's transferred to, and the key of the person that's been transferred away from. And all of that is just encrypted, put in a blob, and that blob of encrypted information can be passed around, transferred, and do whatever you like with it. And the idea is that if you wish to have your key put into there, you do that by coming up to an exchange with a person who has got their own key and has something on that ledger, and you do a barter transaction. And essentially you get a piece of software that says, add to the ledger, please, the taking away of some fraction of Bitcoin from this person and giving it to that person. And that then gets encrypted and put into this thing. And they call it a blockchain because the thing obviously gets quite big over time. And the kind of cool thing is, after a period of time, is you can just, we recognize such things exist, so we'll just chop things off that we don't need to. The transactions that have been and gone, we don't really need them after a period of time. If this person transferred to this person, that person's left the blockchain, they can just be removed. And because it's distributed, no one cares where these things are stored. So you can just copy and paste them as many times as you like, all right, in and around the show. And it's that idea that you can only get into it with your key. You can only get into that blob and to actually go and have a transaction to where I can assign it to another key by entering essentially my very complicated password. So that's essentially all they are. I probably didn't explain that very well, did I? That's cryptocurrency. Well, no, essentially it's information. It's a ledger. So if you think of it in terms of your accounting, well, anything like barter. All transactions you have, if I want some Bitcoin and you have in this distributed ledger associated with your special password key thing, all right, I can say to you, I would like some of that Bitcoin, and you go, okay. And we get a piece of software that says, let's add an item to this ledger, taking away from this encrypted password and adding it to this encrypted password. All right, and that ledger, you then distribute that around. So everybody's up to date. Okay, everybody, okay, we've updated this, and that's fine. It just passes around a bunch of servers. And that's fundamentally how it works. It seems silly, when I say it. And they're like, why would anyone do this? Well, yeah, it's essentially, yeah. It's just basically just a blob of binary information that's heavily encrypted. So all you have is your key to get in. And so other people will see when they've got this blob, because remember that the information without a key, this is just a big blob of binary data. No one cares. You can copy and paste it around, do whatever. It's not worth anything if you don't have a password to get in to that ledger and say, I would like to assign from my key to this other person's key. It's worthless otherwise. It's a big blob of binary data. It's like a text file or whatever like that. It's not worth anything to anyone else because it's all completely encrypted. Was this a terrible explanation for those that already... What do you do with any money, currency? Currency must be inherently worthless. Currency, little notes, what do you use them for? Making paper darts? Currency has no intrinsic value. No, but that's the next one. Other people recognize it as being valuable, and that's what cryptocurrency is. Other people recognize Bitcoin, as an example of one, as being valuable enough to have the incentive to give people stuff in order to get some Bitcoin. That's it. Well, again, some banks, some financial institutions have said, we will give you money in exchange for some fraction of your Bitcoin. Here's our key. We want to put our key in. We'll give you $10,000. You give us 10 Bitcoins. We're better off. It's contract law. You're bartering. No, it's associated with that key. But if you think about it though, when you go into your internet banking, what is it? It's just a bunch of bits and bytes that you're looking at on a screen. So I got paid for the first time this year. It was awesome last night. And so I went in and looked at my bank account. I don't physically see any notes. I just see a little number. Could. Yeah, you could. And that's the thing with Bitcoin. The idea is that, look, it only works while other people find it valuable. All right? And that same thing with money. Money only works if other people find it valuable. If everybody decided, no, we're not going to do this money thing anymore, all of the money in your bank account ceases to have any meaning at all. It's a bunch of zeros in my... What's that? Oh, tulips, yes. There's the great tulip bust, where everybody thought tulips were the most valuable thing ever. And you get these stories of people trading the equivalent of like mansions for wonderful tulips. It was this great bubble. And then it burst when we realized, actually, tulips are not really worth anything, guys. Sorry to burst that bubble. And it did. Yeah, it really is. Yeah. The great tulip bubble. The Dutch are a bit of a weird people. Come on, let's be honest. They're unusual types. Okay, there are some things you do need to note though. Taxation. The ATO wants to tax everything they possibly can. So make note that you can have all the encryption you possibly want. Ha! The ATO can't come knocking. They can't get into it. They need my key. And that, strictly speaking, is correct. The ATO can't come knocking. Do you know what they do? They issue a default assessment. We think that you've got $10 million worth of Bitcoin, and we reverse the onus. And that's why one of the guys, really smart, one of the undergrads, did his thesis on taxation of cryptocurrency. And I'm just like, I said to Stephen Grohr, why don't they just reverse the onus? This is not an issue. You just literally go out to people, we think that you've got all this Bitcoin because you've got all of these houses. You've been trading in Bitcoin. We'd like $10 million, please. And that's what they do. They just reverse the onus. The person who has been alleged to do this. And look, again, we don't like imposing duties on people. We don't do this lightly. But you get these idiots saying, it's trying to spruik Bitcoin. Oh, it's the best thing ever because the tax man can't come and get it off you. And it's like, well, yeah, no, that's right. But they can come to you and say, we'd like $10 million. So good work with your encryption. Good job. It's like, I'm a nerd. I've been a nerd a long time. And we used to have this quite bad joke about this people that were really into encryption and encryption technology and how cool they were because they've got 4,096 bits encryption. No one's ever going to be able to hack that. And then this is true. No one's able to do it. But someone can just walk into your house with a $5 screwdriver, hold it at your head and say, tell us the password. So that the system as a whole is not particularly secure, even if the actual encryption side of it is. And so that's why Bitcoin, I've got friends when we were at EDS and we bought Bitcoin. I don't think I did. I don't remember doing it, but one of the other guys did, and he lost the password. It was 2005. It was a long time ago. We just lost it. And so he's like, no, that's like $100,000. Yeah, it was. Yeah, funny, eh? That's life.
Are you saying that it will be when you are Bitcoin?
Yeah.
Like,
The ATO will have a guess. Usually they'll have a guess and they'll guess really high. And because they've guessed really high, you as the person who's done all these transactions usually it changes the incentive. The incentive is for a person who has been dealing in cryptocurrency and didn't want to tell anyone to actually come forward and say, oh, no, I did make a bit of money, but it wasn't $10 million, Your Honor. That's really the key thing. The mechanism they use is just to reverse the onus on those things. They don't do it lightly. They don't try and do it for everyone. It would be pretty horrible if we, as citizens, I've had a default assessment in the past, not in Australia, but in New Zealand, where they've said, we reckon you've earned this much, Mr. Walker. I'm like, oh, really? Which means I've got to go and do a tax return. Tax returns are actually optional in New Zealand. It's a general rule, but yeah, essentially that's the straightforward mechanism around doing these things. But the ATO still, in Section 23, capital L, I think it is, of the old Tax Act, say when you're dealing with stuff that looks like and smells like income, you just translate it back into what the amount of dollars it would be. So in case of Bitcoin transactions, probably even because they fluctuate quite a lot, your transactions would have to be mapped out and managed and put in your little spreadsheet at the particular day each of those things happen to try and determine what your income is. That's really where that's at. And so there you go. But just because it's not money, though, that last line there, the tax office, they actually consider it to be stock, like trading stock, because it's something that's bartered with rather than being currency. So just, it takes a little bit of time to get your head around that. They consider it to be trading stock, stuff that you've bought and you've sold in the business of crypto. Oh, it would be, yeah. Yeah, it would be if you kept it for over 12 months. Yeah, if you kept it for over 12 months and you purchased it after the year 1985, September 1985. It would. You'd definitely have that. And look, again, if you're in the business of buying and selling Bitcoin, then it's probably not going to be capital in nature. It's all going to be on an income account, essentially. It's your business. You're buying it and you're selling it. But if you've received it in the course of your business, it's probably going to fall under trading stock as well, probably, I would think, rather than strictly speaking under capital account. If you're regularly receiving it, if you do it as a one-off, yeah. With the intention of increasing. With those things, there's a case called Whitfield's Beach. I mean, I'm not delving too much into tax law. Whitfield's Beach and Myers are two cases where they talk about that. If your intention was to purchase it and then on-sell it at greater cost, it's not going to fall under the CGT regime. It's just going to count as income, even though you've kept it for multiple years or periods. If you did purchase it with the intention of holding on to it and using it in some way, I'm not sure how, because as a capital asset, it doesn't do very much. You can't earn interest on Bitcoin, but it can only increase in value. So, yeah, you could argue that's capital in nature, I suppose. But you have to do it over 12 months, because capital CGT doesn't apply if it's less than 12 months. All right. Don't have too much to talk about that. I put that in last year. I mean, it's interesting. One of the other guys here has graded a subject. I actually find IT law, even though I have an IT background, I find the law of technology dull as, really boring myself. I like the technology of the law and the legal profession. That's interesting, but the law of technology is not. So there's the two are in clash. So yeah, it's very much on that side. Okay, what else is there? E-payments code. Again, this is not an industry code. This is one that I think is done by ASIC themselves. I think the industry actually came up with it, but ASIC, they do the regulatory stuff involving it and follow the penalties. And look, it just basically, look, this stuff's all common sense. What you find is that the e-payments code is often put into contracts. So, you guys know what you mean by click wrap is a particular term we use to describe those contracts. You know, when you go to buy something on the internet, it says scroll down to the bottom and click to accept the terms and conditions. No one ever reads them, except yours truly when trying to sign up to tutoring over there. And I read them and I'm like, I'm not going to do this. Thanks, guys. And went to go and see the head of the school as a result. So, look, often these sorts of things end up going in there. Hey, we want to follow the e-payments code, and here are all of the rules we need to do. And look, if you guys are selling things online and you are building these sorts of products, it is worth knowing that this stuff exists, that they have particular bits that they let you copy and paste into your standard form contracts, and it just maps out the rules that you have for dealing with money, how to do, I think, refunds and things like that as well. But how to receive receipts and statements, how terms and conditions change, who pays for unauthorized transactions, basically mapping out how your system works. That's how those things work. And so this is a code which you can follow. I said I don't think it's actually mandatory, but most of the big players do in Australia. Okay, we're going to take, we'll take a few minutes, I think. And then I'll come back and talk about debt and bankruptcy. All right, so take 5 minutes. debt. You guys wouldn't know what I mean by debt. The owing of money to others for whatever particular mechanism or reason. Couple of things to note about debt in terms of security. It's not at all uncommon when you're lending people money to take a registered charge. Charge is something in the contractual arrangement that says if you don't repay this or you fall behind or whatever reason, don't pay the interest, you breach these terms, we have title on the thing that we're holding the charge across. And the most common example of that, in fact, so common in mainstream, they have a different word, is a mortgage. Mortgage essentially says you can't just sell this property until you repay that amount back to us. That's really where it's at. And I've just noticed here that I've actually got a possessory lien. Here's me saying, I didn't assess, this isn't going to be the exam. And I've looked at the exam and said, it does talk about possessory liens, but I think we actually talked about it 2 weeks ago under property law as well. So I'm strictly speaking, I haven't broken my word saying the stuff isn't assessed. A possessory lien. It's run L-I-E-A-N? Well, I think we did talk about that. That's that idea. If you go to the mechanics, for example, and you get your car fixed, they usually take, in the old days it was the rotor. These days, I don't actually know. Anybody who's good on cars these days know what the mechanics take out? They'll take something out of your car to mechanically disable it. Possibly the connection to the computer itself. Possibly just a bunch of fuses if they think you're not very good with cars. I don't know. But essentially they'll take something out of the car so it can't just be, if it's sitting outside, it can't just be picked up and driven away until you pay for it. That's a possessory lien. We're going to hold on to the thing until the work that we've done on it has been paid for. But that only really works in some sort of narrow circumstances. If somebody's giving you stuff and you're doing work on it, that's a pretty narrow set of circumstances, really. More often, you've sold stuff to people and you want to be paid. It's not at all uncommon in business to give people stuff and issue an invoice and then they pay you back 30, 60, 90, whatever the terms of your particular arrangement are. It's quite curious though, if you think about it. You guys ever stop to think about business and how this works as a convention? Because we think about it in our private lives. If you walk into a supermarket and said to them, oh yeah, I'll take the stuff now and pay you back in 30 days time. That sounds bonkers. No supermarket would ever do that. And yet we do this habitually in the business world. Why is that? Because it's essentially you're extending credit and suffering cash flow problems as a result. You've got to purchase the stuff in order to give cash flow benefits to the person who's purchasing it.
It's a continuing entity there.
Yeah, is that what I was? Oh.
Business is likely to be around the person probably won't.
Nice. Okay, that's it. Oh, we're not the first ones to think of this as a phenomenon. I just found it really interesting. It's something I never really understood because it was so commonplace. People would go and do that and have terms. I found it just amazing when me and a friend of mine, we started a business building computers in the year 2000. Well, we strictly speaking started in December 99 because we wanted to say that we started in the 20th century. And we found it amazing that two kids, I was 22 and my friend was 18, and we would walk in with our card or a business AirPods card, whatever like that, and we could walk in and like buy stuff and they'd issue an invoice to two kids. But if you wander in, you've got a registered business and you have a GST number and all of that, and they would just do that. I've just found it just remarkable how businesses would do that, and yet there's just no way you would have that, in your day-to-day life.
The reason could be consumption, because when you are in business, you are not exactly buying it for consumption, but to store it. So in case you don't pay back, you take all this stuff out.
Well, I think so too. I think there's the idea that people don't usually do things on a business-to-business level unless they're actually serious and proper about doing it as well. The expectations and the norms are much higher when we turn up. and we tried to look like we were supposed to be there. Wear good clothes, or wear branded clothes or uniforms or whatever like that. Make it look like you're supposed to be there, and people are much more accepting of that. I just found it always quite remarkable. Nonetheless, there are other things you can do. You said you mortgage across things, you have a charge across it, registered debt. Just note that can go on specific property, or it can go across, floating across either some or all assets. Sometimes it'll be a class of assets. All of these things are governed by contract law. There are systems of registration for some assets, motor vehicles, boats, and land, obviously, the big ones. And when you register those things, there is a central registrar. And when you have security taken out across that, an entry is put onto that registration. And basically, it's a warning to the person coming along afterwards saying, oi, somebody owes money on this particular thing. Now, there used to be this horrible system with motor vehicles where you couldn't tell. There was no system of registration. But at common law, if money was still owed by the previous owner on a vehicle, and then you went and purchased it off that person and money was still owed, you didn't get good title. There's horrible stories about young kids that would pay $10,000, take out loans to buy cars when money was still owed by the previous owner, and the finance company would come along and just take the car away. But I'm like, but it's mine, I paid for it. Nope, you did not get good title. Nemo Datmel. Oh. There you go. You don't get anything back. It's a horrible system, and it's really a hangover from the quite harsh common law rules of going back to the early part of the 20th century or the 1800s as well, where these are the laws of contract, and like a lot of parts of law, it was very much ignorance of the law is no excuse. And it's sort of the other areas that this has happened, things like residential tenancies. These used to be horrible things, where you were governed by the rules of ye old contract law in regards to your paying of rent and doing things like that. You breach the term, say, if you're 5 days behind, you're out. And then you come in and find all your stuff's been tipped out and they've got someone else in. We recognise that these things are problematic, and that's why we put regulations in place. So if anybody whinges about regulation and this being red tape, cutting through red tape, it's always the hallmark of the centre right when it come election time. This putting regulation in place in our society, we only do it because we think it's going to make a better world. And I think most of the time that's right. It means that we, as citizens, can go out in the world, do stuff, and not have to know what all the laws are, because there's more and more and more laws, and it just gets harder. Don't get me wrong, I'm saying I'm glad you guys turned up and did the subject, because you are more powerful relative to everyone else as a result. But we always have to cater for the lowest common denominator. People that don't know anything, going to the supermarket, don't know anything in terms of remedies, nothing in terms of those things. Just make the supermarkets follow these, consumer protections. It just makes it easier for everyone. Okay, a Ramalpa clause. I had to learn about this one. I remember this when I did business. Does that sound familiar? It comes from this case, Ramalpa Aluminium. It's basically a retention of title clause. When you sell stuff, you can put in the contract a clause that says, if you don't pay, we own this stuff. Because usually when you're selling stuff, you're quite happy with title to pass to the person who's buying it. Why? Because risk goes with title, and they have to pay for it. They're obliged to pay for it. That can be problematic, though, if they ain't got no money. In that situation, you really don't want title to pass. And so you can structure your contract accordingly. You can actually put a clause in there that says, risk passes to you guys upon delivery, title passes when payment passes. And like everything in the Sale of Goods Act, what you put in the contract will trump what the Sale of Goods Act says in terms of these default rules. It is okay to have Ramalpa clauses, as we call them, in contracts. And if you guys are selling things, large things, you might want to do that. Put it in the contract because you don't trust the person who's buying it.
So what did you say? Risk passes on delivery?
You can put in your contract whatever you like in terms of when risk passes. That's really the key thing. So a Ramalpa clause essentially says, title doesn't pass until it's been paid for. But we don't want to have title and risk as well, because if we sell something to these guys, these rat bags, and then it gets stolen, it's a bit mean. We don't want to have to, for their carelessness, we don't want to have to suffer because of this, strictly speaking, our stuff. And then they turn around and say, oh, we don't pay because it got stolen. What we want to have is we deliver the stuff and say risk passes at this point in time, but title, true ownership to those goods, doesn't pass until we've been paid. You can do that.
So is that mean if you delivered stuff
Yep.
and they got stolen,
Yeah.
they would have to pay you?
They would. Yeah, that's right. So the risk of destruction passes with those things. So assuming that you have in your contract that says if the goods are destroyed before they've been paid for, you guys bear the loss. That's fine. The laws of contract, ye old contract law, says you can put clauses like that in. Don't get me wrong. They might say, nah, we don't want to sign that contract. And that just comes down to the power dynamic between the parties. And often the liquidity of entities matters, of big players. And again, this thing is the aluminium case, remarkable aluminium, involved big players. The big players are enough to go to the English courts, the appeals cases. And in that situation, the court said that, look, purchasing a big bunch of aluminium in that particular case, the contract said if it's not paid for, even though it's been delivered, if it's not paid for, we have reserve the right to come and pick it up and take it away again, and revest title in that case. And they said that's fine, you can do that. All right, guarantees. Remember we talked about contracts have consideration flowing from both parties. There is a situation where you lose out in a contract even though no consideration is paid to you. This happens when third parties guarantee usually the debts of related entities. And by related entities, often family members. So if a child is wishing to purchase a house, the bank can say, that's fine, provided your parents guarantee this loan. So if you don't pay, they will have to pay. All right. And guarantees must be in writing. Guarantees are valid under common law and equity and statute as well. Be very, very careful about who you sign guarantees over for. They're valid law, and you often do them again in situations where involve children and kids. So one of the things that's come up in terms of, again, these sort of equitable principles is that when doing a guarantee with banks, they will go through and bend over backwards to make sure you fully understand what the terms of this particular guarantee is, what the risks are, and the potential loss that you're going to suffer as a result. So that's something you just have to be very, very, very mindful of. Don't become a guarantor in something lightly, because your livelihood, your life can be very much suffered by the tardiness of others. All right, so what happens? What happens when things go wrong? And unfortunately, I'm curious as to you guys, and again next week I'm going to try and organise, we'll go into the computer labs and do the little student feedback things. I beg you guys, I don't want you, because I'm going to bring you food, I do not want you guys to give me good feedback because I'm giving you food. All right, that's like the opposite of what I'm after. You can be as scathing as you like. Just make note, if you use profanities in it and say quite terrible things, these days they actually vet the comments. There's a team of people that'll go through and check the comments. Anything that's truly horrible actually gets removed. They do. I used to get, so the woman who was the reason I ended up teaching at JCU, she used to get student feedback for contract law, and she said that it would literally make her cry before it was vetted. It was really horrible. And so I'm a little bit more robust. I'm very unlikely to cry no matter what you say. So just make note. We'll do that next week. I'll get some food in as well. It'll be last week, and we'll be going over the exam, so we'll make it a bit more easygoing. Get some French Merlot. I was just saying like that. We've been watching. I've got to say, on Monday nights we've been for Game of Thrones. We've been getting one of these tube rooms here and setting it out, getting bean bags and getting red wine and cheese, and it's been really good. Very good. Now it's over, and we never talk about this week's episode ever again. Move on. All right, so but one of the things that I did change quite deliberately was to put in your PBL task early on a little task to do with debt. So you guys had to go through the QCAT Act early on. And of course, then you get to learn the material in the week at the end and find out it's not assessed elsewhere. But I think it was a useful task, personally. I hope you guys picked up a few things from that. And one of the things I hope you did pick up is this distinction between a liquidated debt and other types of disputes. A liquidated debt is where the amount is not in dispute, and that's it should be a pretty straightforward concept. Here is we sold these goods, all right. They've accepted that that's what the terms are, and they just didn't pay at all, or they paid some fraction and didn't pay the rest. All right. When the things are not in dispute, and the amount is not in dispute, you can go through a much easier series of steps in order to try and resolve that. Like I said, QCAT will have jurisdiction to do this for small amounts, but a little known fact about a QCAT order is actually not a court order. So you cannot actually go and enforce them. QCAT orders are basically things saying the tribunal has ordered that this person pay this, but there's no backing to that. The only thing you can do is actually walk to the Magistrates Court and get it converted into Magistrate Court Act. So if you talk to the litigators here, Keita Roseby is a senior associate. She's an amazing woman. She teaches civil procedure, and very, 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 very sort of sardonic, sarcastic type way that she lectures. And she says yes. So the first thing you do when you walk out of that QCAT hearing is that you go down the stairs, you walk across the other side, you walk downstairs to the register, and you walk in and you get it converted into a Magistrate Court order. Just don't muck around with things like that, because if they weren't willing to pay and you had to go to QCAT, odds are good they're not going to pay now you've got a QCAT order either. So just leave that. I know. It sounds really dumb when I say that, but pretty much that's it. But also note, these debts and these orders, you can actually transfer them. So you can go and transfer. Oh, sorry. Come back to the thing about orders. If you have a debt that's owed to you by somebody, and you can prove it, and the amount can be proven, all right, the amount is not in dispute, that debt can be on-sold. And so it is not at all uncommon for debt collection agencies to purchase debts, and they do basically say they take a certain number of cents to the dollar. So if there is a debt for $10,000, they will say, look, we will buy this debt off you, and we'll buy it off you for $2,000 or $5,000. They'll do an assessment of what this debt is worth and how hard it's going to be to get money out of these people. And it's their business to track people down and squeeze money out of them through this enforcement process. Okay, that's what debt collectors are. Has anybody ever worked for a debt collector involved? So I can pretty much say bad things about them. It's a horrible business to be in. It is just the pits. It often has a strong sort of criminal element, because you literally, rather than go through the courts, it's much easier to just turn up with some guys with some baseball bats. We're in Australia, with some cricket bats, and just basically brandish them around and say, "Oh, you pay the money now." It always had that vibe to it, and strictly speaking, they can't do that. It's still harassment, and it's strictly speaking against the law to threaten to bash people up. But in terms of debts, you can. I did community legal for a long time, and the debt collection people will call you up and call you up and call you up and keep going and asking, where is this money? Where is this money? Where is this money? And it just drives people crazy. So that's it. So debts, particularly small amounts of private debt, can be just horrible. And that, by the way, is one of the reasons why it's not uncommon for people in those situations to actually declare themselves bankrupt, which I'll talk to in a few more slides, because they just get sick of getting harassed all the time when they've got no money. Okay, what else is there? Now, what can you do? What's the process of enforcing these things? Letter of demand. Somebody owes you money? Oh wow, I've got through this whole lot. This is very good, actually. All right, first things first. Somebody owes you money. You need to send a letter of demand. Now, this is actually required under the Uniform Civil Procedure Rules. And it's important because if a matter has to go to trial, actually go off to court, and you actually have to have a hearing, and things are in dispute, you want to win, obviously. You're the one bringing the action. Now somebody else owes you money. And look, you can flip this around, by the way. If you're the person who owes money, these are the steps they're going to have to go through to try and get it out of you. But if we think about it at the moment, we're trying to get money out of a delinquent customer, for example, who hasn't paid us. The first thing you need to do is send a formal letter of demand. And that letter of demand has to be addressed, and if the entity that you are in dispute with is a corporation, you must send it to their registered postal address. Do not send it anywhere else. It's only effective if it gets sent to their registered address, which usually means, unfortunately, you have to pay the $9 fee in order to actually do a company search to find that information out. You can claim it back later on. If the whole thing goes to trial, you can get that $9 back. But you generally pay the $9, send them a debt, say this is the amount that we've owed, and you must give them 14 days to do this. And you should also pay the $7 to send it registered post. Do you guys know what registered post means? But some of you guys do. I'm not sure the rest of you guys whether they have it. Do you know what registered post is? Do you know that term? Because I suspect it might be an Australian English term. So you do have it? Okay. Okay. It's basically it's a special envelope. You pay a lot more money, like I think $7, and that you get given a tracking number. And the idea is, when that envelope is delivered to somebody, they have to sign that they've received it in order to actually open it and have it given to. So that once they've done that, what that means is that that has been served to them, so they have that information. And once you've got that tracking number, usually do it on the internet these days, that says that the thing has been delivered and accepted, you can use that as evidence to say that you've served this particular document on that party on that particular date. And from that date, they then have 14 days. So you can't carry on and do other steps during that time, during those 14 days. That's really where that's at. So you've got to give them a bit of time to think about it. And again, I've noted here that it affects legal costs. It really does. This affects it. In fact, I might... I've even got it on the next slide. Cool. Now, another thing you need to know, if you receive a letter of demand, but you want to negotiate, it's very important to put those words, I'm not kidding, genuinely put those words on the top of your letter, without prejudice, save as to costs. What that means is that you are demonstrating that you are making a genuine effort to try and resolve this dispute without it going to court. And these are known as Calderbank offers after that case, Calderbank. The idea is the courts don't want anybody to be going to court to solve disputes that they could resolve themselves. Courts are expensive, massive drain on the taxpayer, horrible, stressful places to resolve disputes in. The courts would really want you, and Parliament as well, this is under the UCPR rules, they want you to sort your things out. And one of the mechanisms you can do that is by actually offering to settle. But what you don't want to do is send a letter offering to settle and then have that be used as evidence. So look, Your Honour, look, they're saying that they had they didn't do anything wrong when the thing goes to trial, but here's an offer willing to pay us this sum of money. That should be taken into account. You must put those words on the top of your letter in order to stop your offer to settle from being used as evidence. So tuck that one in the back of your mind, because it's very likely in your life that this is going to come up. Somebody's going to send you a letter of demand, demanding money, and sometimes you're just going to stuff it. We'll just offer a small amount and see if they go away. You need to put those words on the top, usually in capital letters, without prejudice, save as to costs. I'll get to the reason why you have that save as to costs in a little bit. But you need to have at least the words without prejudice, because that means that offer to settle, and it has to be an offer to settle. It can't be other information, arguing them about stuff, and you put that on the top so it can't be evidence. No, genuine offer to settle with those words on it cannot be used as evidence in the court of you agreeing or somehow being complicit in any of your wrongdoing in relation to that transaction. Okay, it goes like this. Because, as a general rule, the loser has to pay the winner. That's how that works. Loser pays the winner. Not many slides to go, guys. And then we're going to go home. All right, so this idea is that loser has to pay winner's costs. That's the starting point. But it's what's called the scale basis or the standard basis, and it's actually mapped out in the Supreme Court rules, and it's usually really low. Like you'd have to have a really seriously cheap solicitor for the costs award that you get to actually meet your legal costs. I don't know. There's no way the scale costs with any solicitor is gonna meet that. So when they say that you win, you get costs. You're only getting costs according to that scale amount by default. But if you are the plaintiff, in other words, you are the person bringing the action, and you win more than the amount that you were willing to settle for, they have to pay your full costs. In other words, what's called the indemnity basis, which can be much, 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 much more. So if you, for example, I will say Emma sold me a boat and I didn't pay, and she then goes to sue me for $100,000, and she offers to settle for 90, and I say, nah, let's go to court, and then she wins 100, I have to pay all of her legal costs. We call that the indemnity basis. It only works for the plaintiff if they make an offer. And look, if you think about it, it kind of makes sense. They had the right. They were right. You as the defendant were wrong about what the legal position were, and they offered to even resolve this for you, to essentially your benefit, and you still said no and made them go to court. Stuff them. Give them one finger salute. And that's what the courts essentially do. Indemnity basis. It's a little bit trickier for the defendant, because the defendant can make an offer, all right, and then the plaintiff can refuse that and then go to court but not win as much. And in that situation, the thing changes. From the point of time when that offer was made, the plaintiff actually has to pay the defendant's costs. And the idea is that, look, from this point onwards, you're wasting everyone's time. You would have got this much if you accepted it, but you carried on stubbornly to go to trial and you only got this much. Therefore, from this point onwards, you're paying their costs. They pay your costs up to that point, because you won. You're the plaintiff, you won, sure, on a scale basis. But from that point onwards, you pay their costs. And again, it's on the standard basis as well. And so that's how that pans out. And again, it's just try to create these incentives for people to settle early. That's how and where that sits. Does that kind of make sense? That makes sense. So it's just tuck it in the back of your mind. It's not assessed. Not assessed. Don't need to know. To be honest, this is the sort of stuff where tuck it in the back of your head somewhere, and if this comes up, go back and look at your notes. Go back through it and go, oh, I remember this. Oh, yeah, sweet, letters. Oh, that's right. Just go through it. It's pretty straightforward to read. It's only a couple of slides. It's hopefully on the internet forever, unless somebody from the uni comes and tells me off. So that's pretty much it. And look, to be honest, when you go and pay expensive lawyers, literally those 3 slides are all they do, day in, day out. It's just litigation's not for me. All right, another thing I might have done earlier on in this subject too was talk about limitation of actions. That is this basic idea. You must get onto it quickly. It's from whenever, and they use this term, this cause of action, or this bare right to sue happens. And appreciate, for contract and for tort, those can be 2 different times. All right, you can actually have situations where contract you can breach at a certain time, whereas in tort it's the harm happening. And so I had a case where it involved negligence on the behalf of her accountant. Accountant gave bad advice, but it had been 6 years since the 6 years had expired for contract. At the point in time where she gave the advice, it wasn't until a few years later that the harm actually happened. So that was more recent. So that was within the time, but the contractual stuff wasn't. Which was one of those things. It means you've got to use tort, and tort law's harder. Contract law's easier. Is there a breach? Yeah. Okay. Can you prove causation? Yeah. All right. Get the checkbook out. We'll do that calculation. If you can calculate the amount, the expected loss, all those things there, or reliance loss in that case, but tort it's harder. Okay, so just make note, most things in law is 6 years. So contract and tort, quasi-tort, things like claims in equity, claims under most breaches, things like breach of statute, they're often all six years in relation to those things. That's most of them. If it's personal injury, it's only 3 years. You actually have to file some claimy type document, register the document with the court within 1 year as well. So even though that the action can be done, you still have to do that some step. I'm not sure. I actually can't remember. I've never done personal injury law matter, and I'm a Kiwi. We have no personal injury law in New Zealand, so it's all alien to me. Defamation. I don't think I put did I put defamation in this course? I think I might have. Yeah, we did talk about defamation. You've got to get on that real fast. It's 12 months. That's a much shorter than the other ones. Which one? Oh, my mum. Yeah. The dogs. Yeah, dogs. That's right. I did talk about that. Yeah. Get onto it fast. Because, yes, the plaintiff in that matter did get onto it quite quickly. And, yes, $20,000. Good job, Mum. Good job. All right. And judgments. So your defamation of is just, if you do get a judgment, you actually can't have that forever. The courts, they do expire. So if your court judgments only last for 12 years is quite a long time. But you have to take steps to actually enforce that within 12 years. Judgment is when you go to court and you win, they create an order. I should have put an order of the court, perhaps is a better way of phrasing that. An order from the court that says, this person must pay you this sum of money. The document is stamped. That has power. That is backed by the Supreme Court of Queensland's their seal. And you, as part of doing this, in fact, it's the next slide. They can go and ask that person to pay, and if they don't pay, they can literally get a bailiff to come and grab the stuff and take it away. Which I'll literally move that right now, because this is what happens when things go poorly, and you go to court and you win, and you get a piece of paper, and the piece of paper is this judgment or order of the court that says this person must pay you this much. So what? We don't care. That's not cash in our bank account. These are the steps that you've got to go through. The first thing they have to do is have what's called a hearing. You actually go, and there was a doctor whose name shall remain nameless, but he's quite famous in North Queensland because he's somewhat of a rat bag and keeps appearing in the paper because he would steal money from his clients. Sorry, they would give him money. Again, fiduciary duties, Anyway, so this doctor rocked up to court. This is on public record. I'm not giving anything confidence away. Literally rocked up to the enforcement hearing and said, actually, I have a deed of release from this particular person who was essentially intellectually impaired. The deed of release that this particular person had signed said that that person had released him from all obligations under the debt. The court order that had been granted in her favour. And we picked it up and looked at it, and the solicitor turns back to her, did you know about this? And she's really just not a very clever lady. And she's like, oh, I did. And she's all in tears. And so the smug git is like, can I go now, Your Honour? And he was like, no, you are here and you have to fill in that form. It was really pretty angry. It was one of those really uncomfortable times to be in court. But he had a deed that said he didn't have to pay, and she'd signed it, and that was quite frustrating for all the people that had worked on that particular matter. Anyway, by the by, so when you've got this order, you can first of all you can call them up and say, "Oi, here's an order, please pay." They won't. So then what you do is you ask the court to set down a time where they have to turn up. If they don't turn up, and often they don't, you can have the thing done in default. Usually, if you can produce information to the court that they have assets. Your Honour, this guy has a Lexus. What do we have? Had a Lexus, had a bunch of watches, had a property out in Oak Valley, had a property in Townsville, had a property in Kerwin. Your Honour, can we please seize the Lexus? Can we please seize this? Can we seize the bank account? Can we ask for a garnishee order on wages? Can we ask for an order garnishing from the bank. And a judge will go through those things. If they have turned up and filled in the form, they'll look at those and work out what the next plan of attack is. But at that point, they can order a bailiff to come and seize the property. Bailiff is appointed by the court to get stuff. And usually they're accompanied by the Queensland Police when they go into a property, grab stuff, take it away and sell it. That's how that works. And they can also get what's called a garnishee order, is to redirect income from that person, from it's going into known bank accounts into other bank accounts, yours usually. And you can also garnish amounts that are in bank accounts as well. And look, at the end of the day, that's the easiest thing. You can get the court to do that, because once you've got that order from the magistrate, or usually magistrate, you just go to the bank. Hey, bank, we'd like this money now. Sort it out. And they do. They have to. So it's an order. They don't care. The bank doesn't care. Oh, here's a court order. We better follow that. Okay, done. All right. So what do you do if you've still got this amount and the person doesn't seem to have much money and they're not willing to go through any of this process? You can petition them to become bankrupt. Now, you as a creditor, if you are owed $5,000, or a group of you as creditors are owed $5,000, you can ask the court to declare this person bankrupt, and all of their stuff ceases to be theirs, which is kind of cool and a little bit scary. But just remember, it's $5,000 for individuals. It's only $2,000 for corporations. So if a corporation goes through and does this, and you've served letter of demand, and then you've gone and got an order from the court, you can then serve notice to their registered post office address for $2,000 or more and have that company liquidated. So this is why, another piece of advice for all you guys that are going to be financial controllers, make sure you check your PO box for your company at least once a week. Because if you get something like this and you run out of time and you haven't checked it for a month or two, you go on holiday, you literally, and you owe $2,001, you could come back and find your company's been liquidated. And good luck trying to undo that. You're done. You're done. Probably lose your job. So just make note, that is what can happen. All right. And this, it's pretty close to the final slide. Second to last slide for the whole subject. You get to go home. All right, so that's what happens with bankruptcy. When somebody goes bankrupt, their stuff is now held essentially in trust. It's held by the trustee in bankruptcy, person appointed, usually by the court, to look after all your stuff. And the idea is that the trustee is not there for your benefit. You are not the person that the things are being held on trust for. You are the scallywag that spent other people's money, and as such, the trustee is quite keen to pay them out first. They want to make sure your creditors get paid. Just make note, some property doesn't actually go into that trustee's hands. And look, these are all pretty commonsensical things. Things like tools that you need to carry on earning an income. Kind of makes sense. You can't carry on living your life, particularly if you're a tradesperson, without tools. So me, for example, if I went bankrupt, I've got other problems because you can't be a solicitor if you're bankrupt. It's an absolute disaster for a legal practitioner, and only a legal practitioner. Oh, and politicians. Yeah, that's it. So I'll try not to go bankrupt. You're allowed a cheap motor vehicle. You go up to $8,000. I don't know if that gets indexed. I don't think it does. I think it says $8,000. Might be. I put it approximately equal, so maybe it does go up every year. Okay. Oh, there you go. That's a cheap car. That's still a real cheap car. And look, again, that's for policy reasons. We don't want people declaring bankruptcy and then still driving around in their smug Lexuses. That's really the world we want to live in. But yeah, it's all to do. You still want to leave them though the power to go and earn income, because hey, if they can carry an income, they can pay back creditors. It's really good. That's what we want. Other things, superannuation funds. Yeah, so just note your super doesn't, even though you become bankrupt, your super stays. and earning income, household property. Yeah, they don't take your clothes. That's just pointless. Stuff's not worth anything anyway. Australia is one of those countries, it's really unusual in that because the currency is quite valuable, and thanks to Chinese economic manufacturing miracle, stuff is relatively cheap. Labor is expensive, stuff is cheap. And so the cost of clothes is just meaningless in terms of people when they're going bankrupt. Rights to recover damages and compensation for personal injury. Yeah, if you're going to receive money for personal injury matters, that usually doesn't go to the trustee either because that's kind of pointless. And what have you got? So you've got superannuation funds, interest and regular, life assurance and so on. You know, things you don't want to have widowers funds and things like that going into. These are just cynical political things that have gone into the stuff. So when people go bankrupt, they're going to retain some assets that are intrinsically keyed to them. And the first one's interesting. Remember how we talked about trusts? If you are a trustee and you go bankrupt, that doesn't change. Your status as a trustee doesn't change, which seems a little bit quirky. That you can still be a trustee on something like even a family trust with yourself as the beneficiary and go bankrupt. And that's why trusts, the creation of trusts can be a very, very, very powerful mechanism to defeat creditors. But because it's an equity, you cannot do it while there are dark clouds on the horizon. Set your family trusts up a long time in advance and advise your clients to do that too. They're going to be doing things. 2 or 3 years is usually the ballpark figure for that. If you're going to go in to do some risky stuff and you know it, 6 months' time, trust is probably not going to save you. The court's just going to ignore it, just go straight through. But just make note, so trusts are kind of immune to a whole bunch of these things. So that's worth thinking about. And it's my last slide. Right, very last slide. The whole subject. Oh, is it going to transition? Or did I crash it? Oh, no, there it is. For 3 years. Bankrupts can't do a bunch of things. So they have to, first of all, give the trustee a statement of their actual financial position, tell them where all the assets are. I think what else do they do? They have to, I think they surrender their passport. Yeah, they do. So when you're bankrupt, you lose your passport. You can't go overseas without the trustee's permission. There's a whole bunch of things you can't usually obtain credit. You'd have to be quite poor as a lender to lend to a bankrupt directly. But no, in theory they don't. That's actually, sadly, it does happen. So they'll walk into the Telstra shop and get a phone plan, and not. They ought to. In fact, I think it's a positive duty. I think not obtain credit exceeding $6,000. I think you have to tell people. I haven't got it in there. When you're going and applying for credit, I think you're supposed to say, I'm an undischarged bankrupt. That's the term, by the way, undischarged. Means you haven't discharged the period of your bankruptcy. And you do it for 3 years. I didn't put the time in there. Usually it's 3 years. 2 years? 3 years. I think it's 3 years. And look, bankruptcy is a tricky thing. It's really sitting between two policy goals. We want people to, when they borrow money, to pay it back. That's the world we want to live in. We don't want people just, don't want to pay this back today. It has to have some sort of consequence here. But we also don't want people to be scarred for life. Sometimes you can go into the world, make bad decisions, or things can just go poorly, or things that you thought were going to work didn't work, and you can end up in all sorts of trouble. And I see this with young people. It's really sad. Kids that go borrow lots of money to buy big fancy cars, crash them, don't get insurance, owe $20,000. What do? Having these kids that don't earn very much now saddled with these massive debts, worthless debts at high interest rates. It's not uncommon for me to say, look, just go become bankrupt. It's just easier. Sometimes you can have what's called a structured debt plan. They call this a plan you can reach, and it's against governed by the regulator. I can't remember which the regulator is. Finance Ombudsman, something like that. You can have these structured plans to try and get all the creditors together to avoid bankruptcy. Often those are actually more hassle than they're worth because they're just not digging themselves out of the hole. Particularly young guy. And there's this awful I'm not going to name names, but there are a bunch of hire purchase and rental properties that lend people money or essentially help them buy things like furniture and whiteware, cell phones, sometimes things they don't need to buy brand new, and they end up with $5,000 as a debt. And it's like, well, $5,000 may or may not be a lot of money to you guys, but to young people, that's a huge amount, eh? And they struggle to repay, and it's just horrible. Consumer debt, I think, is just one of the worst things for young people. But anyway, that's my 2 cents. Yeah, you can't be a company director. That's the other thing you can't do. So you can't run for Parliament. You might be able to run for state Parliament, but I'm pretty sure you can't run for federal Parliament if you're bankrupt. Just during the 3 years. No, I think it is just during that period. I think afterwards you can. I think we've had MPs that have been bankrupt in the past. You know, colourful lives. And yeah, you've just got to do a bunch of things and tell the trustee a bunch of things before you act on stuff. And look, to be honest, the amount of times that this comes up where people just go and they just don't comply with it, they just don't care. Yeah. They're the sort of lives that you guys doing an MBA subject, level 9 AQF subject at a university and studying law and accounting stuff, you're probably not living those sorts of lives, but appreciate a lot of people out there are. And it's you. At the end of the day, you wouldn't want to swap their lives for yours for $1 million. So that's always my comment on that. You know, you guys are on the up, and there are people that are on the down, and this bankruptcy is the sort of mechanism that is designed to bring you back to zero. You know, have a clean slate, a fresh start, and so you can essentially go and live your life again. Sometimes it works, usually it doesn't, but that's what it's there for. And that, I believe, is the end of days for the content for this subject. So, next week, we're going to be doing some revision. We'll spend the whole time. We'll finish quite a bit early today. We will go over the exam. We'll go over it in details. I'm going to tell you again. I won't tell you exactly what's in the exam, but I will be very, very clear about what you ought to be going and studying and the best strategy that you should be doing for going through and doing that. So, yeah. If I find them, I'll tell you what. No, I see that one there. I believe that Steve has released them. In fact, I'm very sure they can. Previous year exams. I can't put last year's exam, but I can put the earlier exams in there. In fact, I will go through now and see if I can find them literally right now and see if I can put them on NJCU. So how about I do that right now? And I'll close this recording off, end the stream for this semester. End it for this semester. And let's go and see if we can find some of these and plop them up on LearnJCU.